Hello, it's Philip Taylor speaking from Richmond Green Chambers, and this morning I'm looking at a new edition of a work I've reviewed before. I'm excited to do it because it's a good book. It's Abuse of Process by Colin Wells. It's now in a second edition and published now by Jordan's. It's got 4 contributors as well: Paul Hynes, Queen's Counsel, Carolyn Robson, Kris Gledhill and Niyazi. Now I think this is an important book. There's some comment on the back, and you'll notice one of my comments is there. A great addition to the Chambers, it says in the Barrister, and that's what I said about the first edition. I was enthusiastic about it then, and I still remain enthusiastic because this is an area of law that we all need to know about, especially if you are counsel. We've given it a title: For All Criminal Solicitors, Barristers, the Judiciary and the Police. A wealth of practical and tactical advice on abuse of process, and that's exactly what it is. Tactics do come into this because in our introductory comments, which is appearing obviously as a review on the web and elsewhere, if it can be said of a defendant in a criminal case that he cannot have a fair trial, or that it would be unfair to try him, the matter of abuse of process suddenly looms as the most salient and important issue. The subject is complex, of course, and very topical. Check out the chapter on adverse publicity, for instance, which is why, with this important new book by Colin Wells as a second edition, we welcome it from Jordan's. It's obviously written in collaboration with other people who I've mentioned, and it examines the concept of abuse of process and clearly explains the way it operates over an extremely wide range of circumstances within the criminal justice system. There are some very useful pointers, of course, on the European Convention for the Protection of Human Rights in particular, and it is an area where, as I've indicated before, abuse of process must be looked at very seriously if something has gone wrong. Quoting the Lord Chief Justice Roger Ormerod from some time ago, he refers to the power to stop a prosecution which arises only when it is an abuse of the process of the court. The ultimate objective of this discretionary power is to ensure that there should be a fair trial according to law, which involves fairness both to the defendant and the prosecution. And that is the key point. There must be this element of fairness, which is the thread that runs through the common law. So you can have concepts, theories and definitions and so forth, but the book itself is an authoritative and accessible guide to the practicalities of how to make an application to stay proceedings. I mentioned before that prior to having this book, and I've always been very pleased to know of its existence, I found it much more difficult to do these matters when I had to use Archbold. No disrespect to the editors of Archbold, but frankly we do need something that's as simple and helpful as possible. That's what we've got from Colin Wells and his colleagues, and I'm really delighted to welcome the new edition. I think it's a useful resource for anybody who is a practitioner in this area of law, so thank you to all concerned, and I'm delighted it's in a second edition from Jordan's. Thanks a lot. Bye bye.